Our top story right now picks up on what I've discussed with you sometimes as a kind of season of accountability. These things aren't formally scheduled, of course, but you can kind of feel it in the air if you follow the news and see how many different issues have hit the courts. Tonight, we are reporting on the civil rape case against Donald Trump going to the jury. That's after closing arguments today, a time where lawyers for E. Jean Carroll replayed some of that damning video testimony from Trump himself, as well as him watching himself and his under oath admissions. And the argument they made, in essence, is one that may be familiar to you, but it matters because it's what the jury is considering tonight. They presented him as the evidence that Trump is their case, telling jurors this is who he is, this is his modus operandi, his M.O., and arguing that the conduct he's evinced, that's at issue in the trial because they're allegations, but conduct that they say that has been shown through their evidence more than one occasion by Donald Trump shows, quote, he knows what he did. They also showed the jury Trump's reaction to his own admissions on that Access Hollywood video, which was so infamous on the campaign trail and Donald Trump ultimately rebounding from it. But here it was a very different context. Then they methodically tried in these closing arguments to pick apart how Donald Trump has spoken about his own claims of what he says, quote, stars can do. The lawyer telling the jurors he actually used the word fortunately describing sexual assault. Who would say fortunately? Someone who thinks they're a star. The lawyer there pushing jurors to basically see an admission in Donald Trump's own statements, both then, the original statements he made, and now when he did refer to that sentence fragment as something that fortunately stars can do. And they're using that to hold it against Trump as well, that he argued this alleged victim would not have been, quote, his type. Again, turning back to closing arguments, Carroll's lawyer says, in other words, quote, she was not attractive enough to sexually assault, end quote. Now, that's the closing argument against Donald Trump using his own statements. The lawyer also separately went beyond the statements to try to show what they learned by forcing him under oath and argue to the juror that that also undercut other things Trump claimed. It drew on a moment we reported on last week, you may recall. This was during Trump's deposition, which is now public, and he confuses Carroll, the accuser in this case, with his ex-wife at one point. So they argue that showed that Carroll was, if nothing else, quote, exactly his type. Now, I want to mention to you there, this is something lawyers do in argument. It's hard to imagine that lawyer, Roberta Kaplan, speaking that way in the abstract in court, speaking about whether a woman who is an accuser regarding sexual assault is someone's type. What she's doing there, quite deliberately, is quoting Trump to say, well, we'll use your framework for the sake of argument, and she is your type, quote unquote. Now, Donald Trump's defense focused on Carroll's accusations. And Trump's lawyer, Joe Tacopina, is a name you may know well by now for following all this. You can see him directly to Donald Trump's left in this. Well, let's go back to the wider shot if we have it. Yeah, here you're going to see, I want to show you guys. This is Joe Tacopina there to Trump's left. You also see Boris Epshteyn. And that is, of course, Donald Trump's lawyer in that other very big case, the criminal arraignment of Donald Trump. But Mr. Tacopina is also Donald Trump's attorney in this civil case. And I mention that because he was the person that Donald Trump put out to close down the case here before it goes to the jury. And he told the jurors the accuser's story, this is quoting Mr. Tacopina, is, quote, unbelievable fiction. He also tried to bear down on the age of this accusation, or what he called a story, saying, quote, how do you prove a negative? How do you prove you didn't do it? Where were you on some unknown date some 20 years ago? Tacopina also hinted at political motives that might be, in his view, somehow used against Donald Trump beyond simply the underlying allegations. He said, quote, they want you to hate Trump enough to ignore the facts. Now, this is a case about Donald Trump's conduct, not his politics, which many people may hate for various reasons, not his many other offensive statements by themselves. And I will tell you, as we handicap this case before we bring in our experts, there are potentially valid arguments that you heard there from Trump's lawyer. For example, there's well-known precedent that disfavors cases about claims or incidents that are from a very long time ago, and that is for the reason Tacopina cited, that it can be hard for anyone, forget Trump for a minute, for anyone in a courtroom to present a firm alibi for exactly where they were for a single hour, say, decades ago. And to understand a case, you have to have your mind open to all the arguments and evidence if you really want to understand, not just prejudge, what's happening in that courtroom. And you have to do that, if you want to do that, to do it correctly under the law, you have to do that regardless of what you may think of the defendant. But those arguments from Mr. Tacopina, they certainly do not end a case like this any more than Trump's recent objections to his criminal indictment in this same city have not dismissed that case. Both cases involve allegations about Trump's lies and alleged crimes. Lying and business fraud, which is why he was seated at that table you see here, allegedly lying and defamation, that's the current civil case, as well as the most important part to the accuser, to Ms. Carroll, lying about the alleged assault to begin with. So resolving the facts of this civil case does boil down to the words of the accuser and the words of the accused. This is what courts call, quite simply, testimonial evidence, because there's no physical evidence from this underlying alleged incident from back then, and there's no direct witnesses to what allegedly occurred between these two people. So how do you weigh that? You have Trump's public denial, but in bad news for him, you also have those private admissions he made on tape on that bus that he thought were forever secret about grabbing women. You also have his rhetoric, his public attacks on this accuser, but then you have his answers under oath, where he actually was caught conflating her with his own former wife. And then you have Carroll's account and what she privately told others around that time, which is largely consistent from this testimonial evidence. In other words, there's what she alleges publicly and in her writing on the case, and then there's what other people testified under oath she told them back then. So if you followed this case, you probably know some of the outlines of this story. And you may have very strong views about the people involved. The justice system, when it works, doesn't put these questions to just someone who might be following a bit of the story, nor does it, if you have to stop and think about it, doesn't put it up to some body of appointed experts. This very significant case about someone who's actually also running to regain power, to rule over this country, this is not up to a judge. There is a jury of 6 men and 3 women that begins deliberating tomorrow. And they have listened to all 8 days of this testimony, as I said, and the arguments on both sides to decide, and this is the legal standard, whether it is more likely than not that Carroll either made this up or told the truth. That Donald Trump really did this and made up his denial, or did he not? What is more likely than not?